Welcome to Halton SENDIASS Information, Advice and Support Podcast. Today's podcast is about requesting a particular nursery, school or college. You can request this whenever you receive a draft education health and care plan or an amendment notice which sets out proposed amendments to an existing plan. So it could be that your child or young person is getting a plan for the very first time. It could be the EHCP is being amended after a review, or if the EHC Plan is being amended at any other time. For example, if your child or young person has moved schools, then the plan would need to be amended to reflect that. Whenever a plan is issued at draft, the LA must give you at least 15 days to request a setting you would like to be named in it, as well, of course, to ask for other changes to the plan and a meeting to discuss it if you would like one. So, first of all, what type of schools and settings can you ask for? Well, you've got a right to request any of the following of nursery, school and colleges named in your plan. You can request a maintained school or nursery, mainstream or special, an academy, mainstream or special, an institute in the further education sector, a non-maintained special school, and a Section 41 school. These are all listed in Section 38.3 of the Children and Families Act 2014. If you do ask for one of these types of settings to be named in your plan, then the local authority must consider your request, and they can only refuse if certain reasons apply. The reasons that the local authority can use are only in limited circumstances, and they again are set out in Section 39.4 of the Children and Families Act 2014. There are no other lawful reasons. Reason number 1, the setting is unsuitable for the age, ability, aptitude or special educational needs of your child or young person. Reason number 2, the attendance of your child or young person will be incompatible with the provision of efficient education of others. Or number 3, the attendance of your child or your young person will be incompatible with the efficient use of resources. If the local authority wished to refuse your placement request, then they would have to prove that at least one of these conditions applies for the refusal to be a lawful one. There is lots of case law here that you can read about, which demonstrates conditions that have been considered around this kind of request. These can be found on IPSEA case law pages. If you do want one of the types of schools that we've mentioned, and the local authority is refusing to consult with them, or if the local authority has rejected your request for a reason other than one of the reasons that I've just named, then of course you can take action and you could come to us and ask about that. If you want to request a mainstream school or college is named in your plan, there is also another part of the law that you can rely on. Section 33, Children and Families Act, says that a child or a young person with a plan must be educated in a mainstream setting unless, number 1, it is against the wishes of the child's parents or the young person, or, number 2, it is incompatible with the provision of efficient education for others, and the LA shows that there are no reasonable steps that it could take to prevent the incompatibility. If you were to request a mainstream school, but your local authority can prove that one of the lawful reasons for refusing to name it applies, then your child still has a right to mainstream education generally. This means that if the local authority wanted to name a special school against your wishes, it would also have to show that mainstream education is incompatible with the provision of education for others and that no reasonable steps which could be taken to prevent. Note, however, that this is a right to mainstream education, but not particularly or necessarily a right to a certain mainstream named school. I will produce 2 more podcasts, one which talks specifically about naming an independent school, which is not a Section 41 school, and also one about resource-based provision and how that would look and be requested when at draft stage of plans. So next I'm going to talk very briefly about what happens after you make your request. When you have asked the local authority for a school of your choice, then the local authority have a duty to consult with those schools. I will do a further podcast about the process of consultation. If at this point you can't find a school or college you want to ask the local authority to name in the plan, and you do not make a request for a particular setting to be named, then the local authority must name a school or college it considers to be appropriate, or name a type of school or college that it considers to be appropriate. It is possible that you may not agree with this and the local authority's choice of setting or the type. You may not agree that it is appropriate for your child or your young person. So, what happens once a school or college is named in the plan? If you ask for a setting, which is one of the types that we talked about earlier, and this section is named in Section I of the plan, then that setting must admit your child or young person. If, for any reason, the setting refused to admit your child, then you could take action. If the local authority refused your placement request and named a different school in Section I, then that named school still has a duty to admit your child, even if you're unhappy with the local authority's choice. You can appeal to the SEND tribunal about the setting which has been named in your plan. SENDIASS are able to give information, advice and support around this process. Occasionally, plans are issued which do not name a setting. They just name the type of setting that the child or young person is to attend. So, for example, mainstream or special. This is lawful if the local authority are able to show the setting requested by the parent or young person should not be named because one of those exceptions applies. It is also lawful when neither the parent, young person or the local authority has been able to identify an appropriate setting. If your EHCP has been finalised with just a setting type to be attended, then this means that there is no school or college with the duty to admit your child and young person. There is also no legal deadline for their plan to be amended to specify that name, in addition to the type of setting. However, once a setting is found for them to attend, your local authority should take steps to amend the plan and to name it. In the meantime, your local authority must make sure that your child or young person gets all of the provision that has been specified in Section F of the plan, and that the responsible commissioning health body still arranges any healthcare provision that's in Section G. If your child is of compulsory school age, your local authority must make sure they receive a suitable alternative education whilst they remain out of education. You can appeal the fact that no school is named. If you receive a final EHC plan and you don't agree with what it says in Section I about the placement, then you can challenge this decision at the SEND tribunal. You should always consider appealing Sections B and F at the same time in such appeals. If the EHC plan only specifies a type of setting and you don't agree with the type of setting, or maybe you do, but you're unhappy that it doesn't specify a particular school, then you can appeal to the SEND tribunal and seek to have a particular school or college or a different type named in the plan. Some families feel that no nursery, school or college would be appropriate for their child due to their SEND needs and the provision that they require. Section 61 of the Children and Families Act allows local authorities to arrange for some or all special provision to be set out in Section F of the plan, and for it to be made otherwise than in early years, school or post-16 settings if the local authority agrees it would be inappropriate for provision to be made in such a setting. This is called EOTAS, Education Other Than at School. Sometimes it's referred to as EOTIS, Education Other Than in School. If you feel that no school or other setting listed would be appropriate for your child, and you do not want such a placement or type of one named in Section I, then you should tell your local authority. Your local authority will need to take into account your views, wishes and feelings, as well as those of your child if you're asking for this as a parent on behalf of your child. They should consider the special provision required, and they should consider whether it would be inappropriate for any of the provision to be delivered in a nursery, school or college, and whether it would be appropriate for some to be delivered in nursery, school or college. Whether it is appropriate for your child or young person's provision to be delivered will depend on facts. The facts that must be considered would include your child's background, medical history, their particular SEN, the facilities that can be provided by a school or other than in a school, the comparative costs of alternatives to the education provisions, the child's reaction to education provisions at school or elsewhere, parents' wishes, and any other particular circumstances that apply to a particular child. You should show with evidence why education in any nursery, school or college would be inappropriate if you want an EOTAS package, not just that the setting which your LA may have suggested is inappropriate. Evidence could include school reports, expert reports, for example from an educational psychologist, your child or your young person's views, and any evidence that you have which shows why your child cannot attend a school. If some provision would be appropriate in a setting, then this setting would be named in Section I of the plan. Please note that EOTAS is very different to elective home education. Elective home education is where a parent has genuinely decided to home educate their child. In doing so, the parent accepts that their local authority has no legal duty to support their child with their SEN. This means that a child with an EHCP plan who is electively home educated may keep their plan and have their plan reviewed by the local authority annually, but their local authority will have no legal duty to secure any of the special educational provision in Section F. This is because the local authority is likely to decide that the parent has made suitable alternative arrangements, which therefore relieves the local authority of its duty in Section 42.2 of the Children and Family Act. The parent will need to fund all support their child requires in respect of their SEN. However, if a child has an EHCP plan and is being educated otherwise than at school, nursery or college, then the LA must still secure all the provision in Section F and ensure that there is sufficient funding to meet its obligations. Thanks for listening. Any questions that you may have, of course, please do come to the SENDIASS service by telephoning 0151 511 7733 or by emailing sendiass@halton.gov.uk.